What's up, everybody? It's Stephen A. Williams, president and founder of thecreditrepairshop.com. And in today's video, we're going to talk a little bit about debt collections. We're going to talk about debt summons if you're being sued by a debt collector. And we're going to talk about can you go to jail for debt? I made a video over the weekend where I just pointed out, because some people had came across one of my older videos that said that, can you go to jail for having a debt? And it has sparked a lot of conversation, and I'm going to get into how debt collectors are having people arrested for debt that is owed. They are using a tactic that the court allows them to use, and I just want to be able to help you avoid that situation. So let's first start with what the debt collectors are doing. Debt collectors are buying up a lot of debt. I actually had jury duty for this week, and I'm in and out of the office depending on when they call me in the court. And I took the liberty to take pictures of all of the debt collection lawsuits that were to be heard in that court, at that courthouse. There was 3 pages full of them. Same attorney was hearing almost every one of the cases. The majority was LVNV funding, and we had another page full of them from Calvary, Calvary SPV 1 LLC. These are nationwide debt collectors. They collect debt in all 50 states, and what they do is they buy debt, and they hire a lawyer in that area to go to court for them to collect on that debt. The name of their game is that they want to get default judgments and have people not show up, or even if they do show up, they didn't have a proper response to the court summons, and they end up getting a judgment or default judgment if you don't show up, and then they're going to garnish the wages. This is what they do. And so the number one way to stop a debt collector is to first respond to that debt collector letter. When they send you that letter in the mail, there's several things that you need to look for. Number one is that they're identifying who they are, how they got the debt, who's the original creditor. They might have a file number, but something that is very important that they sometimes, you won't see this with the national debt collectors, but I still want you to watch out for something that even the national debt collectors might do, is that they won't even have in that letter that you had an opportunity to dispute any or part of that debt. That is something that is required by the Fair Debt Collections Practices Act, is that they have to notify you that you can dispute any of it or all of it. You had that right. Now, here, let's talk about some of the things that might be a violation that they don't even expect you to know about. One violation that they don't expect you to know about is that they cannot send that letter out from a third party. By rule, by the Fair Debt Collections Practices Act, they cannot share your information with unauthorized third parties. So they cannot use a mailing service to send out that letter. They have to send that letter out from their office. In the past, they've gotten away from it, and the way that you can look at it is just look at that piece of mail, and if it looks like it's from a third-party mailing service, that is a violation, and you can have that debt. You can notify them, and that debt they have to stop coming after you for it, and you could potentially get $1,000 simply for that violation. Another violation that they make that you may not be aware of is that in that letter, they cannot change the font size. So they cannot, like on a contract, how they had a small print. No, the print has to be the same size throughout the entire letter. They cannot change any part of the fonts for the letter. They cannot try to make it bold in one, maybe get away with making it bold in one section, but they cannot change the font size. And if you believe that the font size was changed because they made it bold in another section and did not make it bold in that section, they could potentially be in violation. Now, another thing is that if you follow my instructions and you respond to that letter, that's called a 30-day done-in letter. A lot of people get that confused as if that's a bill. It's not actually a bill. It's just notifying you that they've purchased the debt. and also giving you the opportunity to dispute the debt, but also the opportunity, if you don't want to fight, you don't want to dispute, that you can go ahead and pay them. So it's like a letter that has three different three it feeds, or it makes it valid by making sure that they did what they were supposed to do according to the Fair Debt Collection Practices Act. Forgive me, I got a little tongue tied there. So they're actually sending you the Dunning letter, which is notifying you. Inside of that Dunning letter is giving you the opportunity to dispute any or all of it, and it's also identifying who the original creditor was, which is something that they have to do. So now, other things that they don't want you to know about is that when you dispute that letter, they cannot put the information on your credit reports. And if it is on your credit reports, like for some reason they sent it afterwards, they have to notate that it was disputed on your credit report. They have to make that notation. They have 5 days to make that notation. Now, here's the gray area within that, is that they have an upload that they might do monthly. And from what I've seen, some of the times they'll give them that monthly period to be able to put that notification on there. So they have 5 days to put that information on there. If it's past the 5 days and you've made that, if it wasn't notated and you've done that, they are going to be in violation if they didn't do that. Now, if let's just say 30 days passed and you've done that and they didn't put that on there, and you've done an update of your credit monitoring, then they're in violation, because they're supposed to put that you're disputing that information on your with that collection that they're trying to collect from you on. Now, another thing that you need to pay attention to is that if they call you after you've made that dispute and they're trying to collect on it, they have to resolve the dispute first before they can collect on that, before they can continue with the collection. As really, it's supposed to be a 90-day cooling off period, where they give it 90 days to let that dispute process run its course. They need to be able to get all of that information over to you. Something that you need to do also, which is something that I advise someone who had responded to a video on YouTube, is that you need to start, if you're in this situation, you need to start marking down all of your interactions with these debt collectors. That means that you want to take down the name if you end up talking to someone. You want to take down the time if you actually spoke to them, and you also want to take down what they said. And then also, if you've disputed it. So this is what happened with this individual, is that they had sent the dispute. They sent it certified. They used the letter that I'm going to give you at the end of this. They sent that letter certified, and then a few days later, or about 5 days later, they actually called there and said, "What are you going to pay the debt?" They cannot do that. That's actually a violation. But what we're going to do with that specific individual is that we're going to wait to see what they do by the end of the week, and then we're going to put together a response that's going to potentially get the whole debt. They're going to just have to cease all collection on the debt, and then also potentially get relief, which would be $1,000 per violation penalty that they'll have to pay directly to that individual for those violations, because she did her job by marking down, number one, did the certified mail to them, and then mark down the time that they call after they should have received that. But there might be a little bit of gray area within there on them receiving that letter and getting it to the right department. There's always a little wiggle room that they're going to have, just like you got wiggle room on your side. And then the next thing you want to pay attention to is if they call you. Remember my 7 and 7 rule. 7 times in 7 days. If they contact you where you talk to them, they cannot make another call for another 7 days. So they can call you one time, or they can email you one time, or they can text you, or contact you even on social media. That's even included. But they can only do one of those per day for 7 days. If they talk to you, which is an engagement, they cannot do anything for another 7 days. So that's something that you need to know about dealing with debt collectors. Another important thing that you need to know about dealing with debt collectors: if they violate that rule, you can have them cease collection on that debt and potentially pay $1,000 for the violation. But if they can cease on that debt and say that they're not going to sell it, not going to come after you for it. Like, that's the exchange that you agree to for uh, with 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 them knowing that they violated and that you'll just leave it at that. If they cease, that could be a big win for you also. Now let's talk about debt summons. It is very important, like the list that I got here with this big list of 3 pages of people who are being sued by debt collectors. You have a right to respond to the court summons. If you don't respond to the court summons, and you just deny everything, or say you go to court and you just deny everything, I mean, really, you're gonna lose. I mean, I can't say for sure because you never know. Maybe a miracle can happen. You get in front of a judge that might violate and actually help you. You never know. They're supposed to be impartial, but you never know what could happen. But we all know that most of the time what it's going to be is it's going to be a little bit slighted towards the debt collector. They see that judge all the time. Not to say that the judge won't be fair, but this is going to be someone that they're going to see all the time. So if you come into court and you're just denying everything, you can probably bet on coming out of there with a judgment against you. So what you should always do is you should respond to the court summons. I have videos on here that show you exactly what you should do. If you want to step it up and have more of a chance of winning, you can have my company do the response for you. We've help people win their case all across the United States. Big dollar cases. There's a link below this video. You can see the proof. As soon as they put their dismissal, they sent it to us. We put the proof on our website, so you can see we help people do this all the time. This is something that we do, not just making videos about it. This is something that we actually do. Now, so the link is below this video if you need help with that. Before I move on to the next thing about going to jail for debt, the bottom line for all court cases, the bottom line, this is civil. Bottom line is that they say that you owe a certain amount of money. If you can't afford to have our company do the service for you, bottom line is that you need to make them prove the dollar amount. There's ways, you gotta, write your response and just do your best on making them prove how they came up with that claimed amount. That would be the best way to give you a defense that you can put together for yourself to make them at least prove that, and potentially get the judge to give you the opportunity to make them have to do that, because they just can't walk into court unless you don't say anything. They can, but they just can't walk into court and say you owe a certain amount and not prove that. And that at least will get you moving down the right trail to make them prove that. Now, the next thing that we want to talk about is, can you go to jail for a debt that you owe? Can you actually go to jail for a debt that you owe? Now, you cannot. There is no debtor's prison. So I want to make it clear here. There's a lot of people that, I don't know, they don't hear me say it the right way, or maybe they're interpreting what I'm saying the wrong way. I'm going to say it very clear right now. There is no debtor's prison. They cannot put you in jail because of the debt. They cannot put you in jail because of the debt. But so how can they get you arrested because of a debt? Now, this stems from a report that I did from that I read and then did my own video on it from the ACLU. I put that on there from the ACLU, where they talked about people getting arrested all over the United States. Well, in a lot of states. It isn't in every state, but in a number of states where people were being arrested because of debt that they owed. So how were they being able to do this? So when I read through the article, but I just used the article as validation from what I've already experienced with customers, where people came to us and said, hey, I've been arrested because of a debt that I owed. And I was like, are you sure you got arrested for the debt that you owed? And then they said, well, they had me come in and say what I was going to do about the debt. See, this is the thing. The outcome is the same. What they're arresting people on is contempt of court. if you have a judgment and a debt collector sends you a letter from the court saying that you have a judgment and then you don't do anything about it, debt collectors in all 50 states, but not in all 50 states have judges signed off on it. But in all 50 states, if they pushed it, they can have you what they call as a warrant on your body. And it's crazy. They will have you have to come to court to attest, which is really just to say what you're going to do about that debt. That's basically what it comes down to. So I put in that video that what you want to do is you want to have the communications open. If you get a judgment and they send something to your house saying they want you to fill out this financial document, let me tell you, the next thing that comes about if you don't fill that in, because that's the steps. Like if you ever want to know what are the breadcrumbs that are being put out there for me to pay attention to if they're going to try to put a warrant out for my arrest for a judgment that I haven't answered to. That's the breadcrumb. The breadcrumb is that they're going to send a document to your home and they're going to want you to fill out that financial about your job, bank account, all of that stuff. And that's the way that they do it. And then you better bet. And maybe you go the whole time and you never, they have this warrant for your arrest, but you're a great driver and you never get your plates ran. None of that stuff ever happens. And, you're good to go. But it is happening to people. And the crazy thing is that it's happening for people who, if you go to the ACLU website, I'll put the link below this video. If you go to their website, they have where people for as little as a couple of $100 have had arrest warrant for as little as a couple of $100. And in some states, you don't actually have to go through the court process the way that you have to go through in like my state of Wisconsin. You have to get a judgment to be able to pull that stunt in Wisconsin. But there's some states that actually allow you, because it's not because they want to do it that way. They've done it to be able to, where debt collectors have made it to where they can save the court some time by skipping certain processes that they would have to do in other states. And you might be saying, well, in my state, they don't have where, you do a judgment and then they do W-2, garnish my wages and all that stuff. In those states, what they do is they just give people access straight to your bank account. I had someone where they gave them access. They got $6,000 and they were coming for $4,000 to $5,000 more. The bank told them that they already have that sitting in there. So when he deposited money, they were going to take it. So now, not to be building people up on fear. All I do is I'm talking about all of this stuff so we can avoid this stuff. It's not to scare you. Don't be scared of anything. What we want to do is I want to get you to take action. So number one, with the debt collectors, what you do. So let's review. Number one, when I started the video, we talked about if debt collectors send you that letter. What's the first thing you need to do? You need to respond to that letter with a debt validation. At the end of this video, I'm going to give you a letter that you can utilize for that. That is doing a very good job for people when they get that letter and do what I tell them to do. Second one, if you have a court summons, a debt collector is suing you in court, what is the second thing that I told you to do? Is I told you need to respond to that court summons. And what did I tell you to do if you can't afford to have my company do that response for you? What did I tell you to do? I said you show up to court, and in your response that you write to the court is that you just say that you need, that you do, that amount you don't recollect it. And truthfully, truth be known, you don't, because they've beefed it up with fees and late fees and all that stuff. You don't recognize that balance. So you want them to prove how they got to that balance. And the only way that they can prove it is go back to day one and give me everything that I've done with charges and everything so I can reconcile it. And if the judge says, well, they can't do that, but we believe that you owe the money, what amount do you believe that you owe? And if it was $5,000, say you think you recall maybe $1,000. That's what you recall. They ask you the question, that's what you recall. If they say, well, you had an opportunity to go in the back room to settle it because I'm going to do a judgment, well, then go in the back room and offer $1,000. Or whatever amount you feel comfortable with offering so you can resolve it, so you can move forward. That was the second thing I told you to do about court summons. Now, what I tell that you can have a contempt of court against you for a debt, and they can have you arrested on that. Put a warrant out on your body, a body attachment. That's what they call it, for contempt. So the slick thing on it is not for debt. There's no arrest you because of the debt. But when you get into court in front of the judge, what is the whole thing about? It's about that debt. So the outcome of what they did for the contempt of court is essentially arresting you over a debt that you owe from a judgment that was placed on you from a court lawsuit, a civil court lawsuit. So to avoid that, because we're talking about avoiding it, open up communications, talk to them. Even if you don't got it, you don't got it, but you talk to them because they can't put the contempt on you if you're talking to them. All right, so now we went from talking about it, heating you up a little bit so I can alert you so you can take this stuff serious, so you can overcome it. And I gave you ways to overcome each one of those. So I fulfilled my promise on that. So now, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my three pack of letters. Statute of limitations letter for debt that's past the legal statute of limitations to collect, debt validation letter, and cease and desist collection activities letter. Now, if your debt is not past the statute of limitations to collect, I want you to send the cease and desist collection activities letter, send it certified mail, because that can get you into an excellent position to do what I had mentioned earlier in this video. Thank you for your time. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com. Thank you, and until next time.